This is the first of the two antitrust presentations. First one is on the Sherman Act. The second one will be on the Clayton Act and the Federal Trade Commission Act. Well, first to give a little bit of a historical perspective of the antitrust laws coming out. Coming in the late 19th century, there was the problem of large business organizations working together, competitors working together through the use of trust, interlocking directorates, basically working against competition and consumers. And that led to sweeping legislation to combat the ill effects of monopolies in 1890. And the first major piece of legislation from the Congress was the Sherman Antitrust Act of 1890. The principal laws regarding antitrust at the federal level is the Sherman Act of 1890, and then Clayton Act of 1914 and the Federal Trade Commission Act of 1914. It should be noted that the various states have their own antitrust laws, and we're going to note some of these later on when we deal with resale price maintenance, etc. First, an overview of the Sherman Act of 1890. There are two major provisions, Section 1 and Section 2, and this lecture will cover both of those provisions. Section 1 provides that contracts, combinations, and conspiracies in restraint of trade or commerce are illegal. Section 1 applies to more than one firm acting together, unless, of course, that firm is schizophrenic and it bargains with itself. Section 2 provides that it's unlawful to monopolize or attempt to monopolize any part of trade or commerce, and it applies to only one firm acting alone, hence monopoly. Now, these two provisions in the Sherman Act have an extraordinarily large amount of litigation over the years, in large part because the prosecution can be from the government and also from as private rights of action where the injured parties sue. There are certain exceptions to the Sherman Act. Labor unions in normal activities, of course, this is the way that labor unions gain its power, through working together, group boycotts and things of this nature. Farmers' cooperatives, and that's the way farmers work together historically. Insurance companies, because they are protected, and investment companies, because they're protected as well. Now let's look in more detail at the Sherman Act, Section 1. The burden of proof for these prosecutions of contracts, combinations, and conspiracies in restraint of trade fall on the plaintiff, and that plaintiff can be the government or the injured party. As I said, injured parties have a private right of action. They can sue, in essence, in tort under this statute. Well, how do you prove it? There must be some action in concert, that the defendants acted in concert under Section 1, or their actions closely parallel each other with some evidence of prior agreement. Now, reality is that circumstantial evidence can be used to make out a Section 1 violation case. There is not going to be a contract or an agreement written down and signed by the parties in in one file copy or in duplicate originals, agreeing to violate the law. Nobody's that dumb. So it's going to have to be done with piecing the evidence together. There must be some unreasonable restraint of trade, meaning there is a substantially large quantity of goods or services affected. Now you look at the market share or the price and how these are affected, and you look to see, is the competition adversely affected to a significant degree, hence substantially large quantities. So normally what we have in these antitrust violations, we have the courts applying a rule of reason test to them. The test of the rule of reason are these restrictions, are they unreasonably restrictive conditions, meaning the contracts, combinations, or conspiracies in restraint of trade? Would they destroy potentially the competition? And that's the question that you ask. How much effect is it their own competition? There are some violations of Section 1, however, that have no redeeming qualities on their face. Every situation is potentially bad. And these are called per se violations. And the rule of reason doesn't apply to these. By the fact that they exist, they are unlawful. Court doesn't have to consider the economic impact of a per se violation. They're inherently anti-competitive. And the typical types, or the ones that fall under per se violation, to which this rule of reason does not apply, are horizontal price fixing, vertical price fixing, horizontal market division, tying arrangements of a monopolist, and group boycotts, also called group refusal to deal. We'll talk about each one of those separately. First, horizontal price fixing. This is the one that is probably has the most activity under Section 1. It's the easiest to understand as well. The companies at the same level of distribution, meaning manufacturer, retailer, distributor, agree to charge the same price. There is no defense that the price charged is reasonable. There's no defense that it might actually save competition. The agreement to fix prices simply are per se illegal. For example, if Company A and Company B, suppose they are oil producers and they're competitors, they agree to charge the same price of oil at $70 per barrel. It's also, courts have also said in Catalano Inc. versus Target Sales Inc. that it is illegal per se if the purpose and effect of the agreement is for the raising, depressing, fixing, pegging, or stabilizing the price of a commodity in interstate or foreign commerce. In this particular case, Catalano, we have liquor sellers that made an agreement that they would have only cash-based sales and not to have any credit sales. Well, one of the persons or the retailers, liquor retailers, wanted to sell on credit, but it was held to be price fixing. Second per se violation is horizontal market division. This is similar to price fixing. Here the agreement, whether it's express or implied, and the express or implied agreement also applies to price fixing, is that I won't sell my goods in your geographic area and you won't sell your goods in my geographic area. In essence, it's a splitting up of a geographic market. The effect here is, by splitting up the geographic market, you necessarily reduce competition. There is no defense that the competition actually improved as a result. Now, note the difference between horizontal market division and vertical geographic division. The vertical geographic division is typically what you have in a franchisor-franchisee relationship. For example, McDonald's Corporation and McDonald's franchises. Or as it used to be, and until more recently, an example like the Olive Garden Italian restaurant. For a very long time, there was only one Olive Garden restaurant in Memphis. And then, 15 or 20 years later, a second one was added, and now they're all over the place. Within franchising, this is how this vertical geographic market segmentation is. This is how you create value of your franchise and maintain that value. The third type of per se violation is vertical price fixing, also called resale price maintenance. Here the manufacturer, by contract of sale to the retailer or the wholesaler, requires that the goods to be sold at or above a minimum price. Now, you could conceivably have another version of this where you establish a maximum price. But the minimum price typically would be one that affects competition more so. In 1977, the U.S. Supreme Court in State Oil Company versus Kahn said that it is not illegal, per se illegal, in all situations under the Sherman Act. So this, before 1997, it was per se illegal, and then the Supreme Court said in Kahn that not always. And then we go to 2007, where the Supreme Court reversed a long-standing precedent whereby in Legan Creative Leather Products, Inc. versus PSKS, in which the court held that a resale price maintenance agreement is subject to the rule of reason. And under that analysis, a resale price maintenance agreement is illegal only where it is found to be unreasonable because of its anti-competitive impact outweigh its pro-competitive benefits. In such cases, the United States Department of Justice will not criminally prosecute, but victims and the Federal Trade Commission can prosecute in civil court. All right, so what we have basically is we have a reversal of this long-standing rule. It should be noted, however, that states have their own antitrust laws. And in particular, with regards to resale price maintenance, there are 6 states, Maryland, California, New York, Kansas, Illinois, and Michigan, that still hold as a matter of state law that resale price maintenance are per se illegal. Let's give you an example of resale price maintenance. This vertical price fixing. Let's suppose that a manufacturer's sale contract with retailer requires that the retailer sell the manufacturer's copies for at least $5,000 as a condition precedent to the manufacturer being obligated to sell its copiers to that retailer. Well, you can see that it is anti-competitive. But under Ligon Creative Leather Products, the rule of reason is going to apply. Now there is an old exception called the Colgate Doctrine that says if there's no coercion or pressure before the contracting, and the manufacturer tells every retailer that it sells to that you sell at my price or we don't sell to you at all, which basically meaning there are no exceptions, then no one can get harmed as a result of it. The Colgate Doctrine exception. Two other per se violations, generally having fewer incidences in which there is liability. The first one are group boycotts, also called joint refusals to deal. This is where two or more buyers and sellers work in concert to refuse to sell or buy from a group of buyers and sellers or a single buyer or seller. Basically is, let's agree not to sell to this other person over here. All right, in essence, the group boycott. Works the same way in large part that that labor unions work. Let's honor somebody else's picket line and not cross their picket line. It's in essence to put pressure on management of the striking union to make them come to the table. The danger here is the running of a competitor out of business. The second per se violation can be tying arrangements. Now, a tying arrangement is one which the agreement, the seller forces the buyer to purchase a second product or service as a condition of purchasing the first, meaning the two products are tied together. This is the same type of tying arrangement that is illegal under Section 3 of the Clayton Act. But in this particular case, as a per se violation under Section 1 of the Sherman Act, it is only a violation of Section 1, meaning it's only a per se violation, if the seller is a monopolist. If the seller is not a monopolist, there is not a Section 1 per se violation. This is the case in the U.S. versus Microsoft case from about 12 years ago or so, in which Microsoft Corporation required computer manufacturers to install Internet Explorer web browser on the computers as a condition of Microsoft selling to those computer manufacturers, those PC manufacturers, the Microsoft operating system, the Windows operating system. Let's now switch discussion to Section 2 of the Sherman Act. And with regard to Section 2 of the Sherman Act, this deals with monopoly. So what is required for monopolization? And thus monopolization required for violation of Section 2. Well, in order for there to be a monopoly, the corporation, the firm, the company, has to have the power to control price, meaning the company is large enough to control price, or the company is large enough that it possesses the power to exclude competition from the market. It can be either one of those two. So, in making this determination of who is a monopolist and who is not a monopolist, you have to look at the market itself. And so you consider the industry concentration ratio, the percentage of the total sales held by the industry's largest firms. This gives you a measure of how much competition is out there, simply because of the power to control price or entry into the market. The factors in determining whether monopoly powers exist, well, there are several, and here we're just simply borrowing from microeconomics. In fact, there's a lot of this material here is from microeconomics. First and foremost, look at the size of the market share. It's the most important. How much market share does the firm have? How does the firm achieve its size? Does it do it through acting like a monopolist, like buying up competitors? Or does it grow naturally? Think in terms of Microsoft Corporation and the development of first the DOS operating system and then the Windows operating system. And up until we had the handheld devices from the last 10 or 12 years or so, Windows had an extraordinary market share compared to everybody else. But in obtaining this market share, Windows simply, or Microsoft simply, had the best product, and other competitors like IBM with their OS X and Linux Red Hat and Apple with its operating system simply could not compete because buyers preferred the PC-based computers with the Windows, DOS, and then the Windows operating systems. Next, you consider the number of competitors in the industry and their respective financial strength. Number 4, how much unlawful pressure has the firm put on competitors in obtaining market share? Threats, things of this nature. And then lastly, the extent the firm has directly or indirectly prevented potential competitors from entering the market. Maybe buying up patents, for example, that would have allowed competition. So, in looking at this market share and the effects that a monopolist may have, we have to consider the relevant product market. The courts have to determine this relevant product market to measure the market share. How narrow is it or how broad is it? Here we want to borrow from microeconomics the concept of substitutability. And remember the basic microeconomic concepts of substitutability. When products are substitutable, if one seller of a product raises its price of the product, then in competition, the product consumers will substitute that product for a generally an inferior product, or at least a substitute product. The reason is a monopoly may exist in a narrow product market, meaning if there's a single product, but the monopoly may not exist if the product market is broad, meaning there's multiple products in the market. In an old case, 1956 U.S. Supreme Court case, U.S. versus DuPont. Here we have the Department of Justice suing the manufacturers of cellophane DuPont as a monopolist. The government is claiming that DuPont is a monopolist in the cellophane wrap market. Well, the issue is, what was the relevant product market? And the court held in this case that the test of determining monopoly based on a single product versus a multiple product market is one when there's a high degree of functional interchangeability between two or more products. The relevant product market should ordinarily be defined to include all such products. This is this principle of substitutability, in effect, the functional interchangeability. And two, the extent or responsiveness of the sales of one product to the price changes of another product. Is there a high correlation of cross-elasticity? Then the product market consists of all of the products and not just the single product. Again, substitutability. Now, in this particular case with DuPont in the cellophane wrap, DuPont was successful in fighting off a claim of monopoly, a Section 2 violation by the government, because they were able to prove that the cellophane wrap was not a single product market, that the relevant product market included all of the substitutes. Now think about, from the 1950s, what the substitutes were for the flexible plastic wrap. There was butcher paper, there was brown wrapping paper, freezer bags with the old twist top tie. This is before the Ziploc type freezer bags. There were brown paper bags, say, like lunch bags and things of this nature. There was aluminum foil. Now, considering all of those as the relevant product market because they were substitutable and there was functional interchangeability, DuPont did not maintain a monopoly in the flexible plastic wrap. Monopolists have certain defenses under Section 2. First is the thrust upon defense. If a monopoly can prove that its size is due entirely to superior production or marketing policies rather than to relying on policies and measures purposefully aimed at excluding potential customers. Meaning the monopoly was thrust upon the firm. An example of this would be Microsoft with regards to the operating system. First DOS and then Windows. The second defense are larger companies in an oligopolistic market that has not acted in concert with other competitors in the same monopoly. Meaning there are only a few actors in the market. This is how you would define an oligopoly. And third, the monopoly was created because of a patent or copyright gave exclusive rights. Now, it should be noted that a firm that has these exclusive rights of copyright or patent cannot act like a monopolist. You may have exclusive rights, but you cannot push your weight around and act like a monopolist. That ends the discussion on the Sherman Act. The next lecture video will be on the Clayton Act and the Federal Trade Commission Act.